I'm Charla Jackson, Domestic Violence and Sexual Assault Prosecutor for the Prosecuting Attorneys Council of Georgia. Family violence in Georgia is defined primarily in three statutes: OCGA 19-13-1, which is also known as the Family Violence Act, OCGA 17-4-20, and OCGA 17-4-20.1. These statutes define family violence crimes by crime type and relationship of disputants. OCGA 17-4-20 gives the criteria for warrantless arrests and defines agency responsibility to provide training for officers with regard to family violence and elder abuse. A qualifying family violence crime may result in the officer making an arrest with or without a warrant when the officer is available or is able to establish probable cause. Aggressive arrest policies have proven to be the most effective law enforcement intervention in family violence cases. OCGA 17-4-20.1 contains requirements for officers when responding to a reported incident of family violence. Georgia family violence law provides a number of chargeable misdemeanor crimes which may help to prevent further incidents. When arrest is not possible, written documentation of the incident and victim services referrals by the officers are still required. The Family Violence Act defines incidents of family violence by crime type and relationship of the disputants. Family violence is primarily a crime of power and control. The victim-offender relationship impacts the investigation, prosecution, and safety of the victim during this process. The investigating officer has a critical role in assessing the offender's access to the victim. Most family violence incidents will be charged as misdemeanors. The likelihood that the offender will be out of jail on bond prior to the trial is very high. Proper assessment of the relationship aids prosecutors and judges to make effective bond decisions. The investigating officer should never minimize the effectiveness of intervention at the misdemeanor level. Misdemeanor crimes charged under the Family Violence Act may carry enhanced penalties. This code section allows officers to make arrests with or without a warrant when sufficient probable cause exists to believe a crime of family violence has occurred. The crime is charged as a crime against the state. Georgia is not a mandatory arrest state. However, most agencies have pro-arrest policies when probable cause can be determined. Aggressive investigation and arrest on family violence incidents is the most effective law enforcement intervention. In cases where there is insufficient probable cause for arrest, the officer still has the obligation to document the incident and to advise the victim of other services available. This statute clearly states what the officer should do whenever they receive a reported incident of family violence. The Georgia court has been clear that it is a directive. This means every time that the investigating officer is required to respond to the incident, they must interview all participants and witnesses, document in accordance with the state family violence report, and advise the victim of all available services. A crime is by definition a public wrong against the state. It is not normally an acceptable defense that the person wronged by a criminal has condoned the offense. See Simpson v. State, 214 Georgia App 587. It's a 1994 case. The officer's decision to arrest should be based on the establishment of probable cause to believe a crime was committed. The consent of the victim or the victim's willingness to prosecute should not be a consideration in arrest decisions. When building the case for prosecution, the officer should remember that victims of family violence may recant their testimony. Documentation of physical evidence, statements of all parties, and officer observations of the scene and disputants are necessary elements of the investigation. The officer should never fail to arrest because the victim refuses to cooperate on scene or that the officer believes the victim will refuse to cooperate with the prosecution. The investigating officer must remember that the victim is always at risk of further injury when cooperating with the prosecution. Understanding the victim's fear of retaliation may help the officer work past the frustration of the uncooperative victim. OCGA 17-4-20-.1 details the steps for the responding officer's investigation of reported incidents of family violence. The statute provides a strategy for interviewing disputants safely and effectively, making assessments about who should be charged as a primary physical aggressor, and the detailed reporting requirements. Officers should familiarize themselves with this statute as well as specific department policies regarding response to family violence incidents and departmental reports. Officers should treat family violence calls as priority calls. The safety of all parties involved may depend on a timely response by the officer. Department policy on response and supervisory instruction should determine the method of response. Officers must defer to supervisors and department policy with regard to entering a residence when the parties resist. First responding officers will have the best opportunity to observe the victim, offender, and witnesses while they are still under the influence of the event. Evidence on family violence scenes changes as the emotional disturbance subsides. The statements made at first contact will often be the most truthful from all parties. Remember, victim stories may change. Documentation by the first responding officers on the scene is critical. There is a small window of opportunity to capture the incident in the most truthful light. It is important for responding officers to observe and document the condition of the scene of all parties involved. Creating a safe scene is the officer's first responsibility. Once the disputants are separated, the officer can begin to interview and assess the statements against the physical evidence. The officer may have to continue to point uncooperative or untruthful subjects back to what the evidence is showing. All involved parties and any other witnesses, including children, should be interviewed. The responding officer should never leave the scene until ensuring the welfare of everyone in the residence. The victim's statement may change once they've had time to come down from the immediate fear or anger of the incident. It is important for the responding officer to get an accurate and complete statement at the time of the incident. It is a good strategy to use the evidence on scene to help clarify any contradictory or unclear points in the victim testimony.
Hi, I'm Amanda Blanchard. I'm the Director of Victim Assistance with the Fulton County Solicitor General's Office. I'm also the co-chair of the Fulton County Family Violence Task Force. Our task force is made up of personnel from law enforcement, the courts, medical personnel, family violence intervention providers, and victim services. Members of law enforcement are always welcome to come to our meetings. You can find out information about our task force by going to fultonfvtaskforce.com. Asking questions about the first time the victim can remember any violence in the relationship can help to establish a pattern or a history of abuse. The officer is building a case on the evidence of the current or most recent event. Prior incidents of family violence between the defendant and the same victim may be used at trial to establish prior history of violence in the relationship. These previous incidents may be useful in prosecution, as well as helping the victim to assess future risk. The officer should also ask about the offender's history of violence in previous relationships. The victim is often a good source for this information. These prior abusive behaviors may also be used at trial if substantiated. The professional response by the first officer to have contact with the victim has been shown to influence the cooperation of the victim throughout the criminal justice process. It is helpful for the officer to reassure the victim that the abuse is unacceptable and that the victim is not responsible for the behavior of the abuser. The first responding officer should document all excited utterance statements by all parties. Observation of the demeanor and physical condition of the person making the statement should be documented in the officer's report. The physical and mental condition of the person making the statement may help to validate the statement later. The officer should attempt to video or audio record any statements. Written statements are valuable tools for prosecutors at trial. When completing the victim interview, the officer should ask specific questions about injuries and other physical evidence. This is the best time to get the victim to commit to an accurate statement. If the victim has injuries, the officer may want to have them sign a medical release form in the event that medical treatment is sought. The victim should be given written contact information for both governmental and non-governmental services. The officer should also encourage the victim to utilize local services available to them. The elements of a good report and case file include interviews of all parties with knowledge of the incident. This includes all witnesses and any children. Once again, any documentation of prior history, whether reported to law enforcement or not, is crucial. Victim and witness testimony may change prior to trial. Physical evidence is the only infallible piece of evidence. Failure to properly obtain and document physical evidence may result in no evidence at trial. Photographs are an excellent way to document injuries, property destruction, physical appearance, and the presence of children on the scene. Injuries will heal. Sometimes the photograph may be the only evidence of the injury. In keeping with department policy, recordings of 911 calls should be requested in all cases resulting in an arrest. When victims or witnesses become unavailable for cross-examination at a trial, much of the testimonial evidence may be lost. As a general rule, calls for emergency assistance can still be used at trial, even when the caller is not available. 911 calls have tremendous value when played in court. Typically, the caller is in an excited state, and additionally, background noises from the ongoing incident may be heard. Recordings of calls to 911 by victims or witnesses may often be admitted even when the victim recants her testimony. Every family violence incident will not result in an arrest. In these cases, the officer should provide the victim with as much information on local services as possible. There is clear evidence that victims who utilize services beyond law enforcement have a greater chance of surviving the abusive relationship. The professional, consistent response of law enforcement to family violence incidents is a critical first step towards survival for many victims. Aggressive investigation and arrest, coupled with concise documentation, aids the criminal justice system in providing for the safety of victims and the accountability of offenders. First responding officers have the greatest opportunity to create positive change for the victim of abuse and the abuser. Adherence to state statutory requirements and department policy with regard to family violence response is an effective deterrent to further violence.